Tough questions were posed to the Electoral Commission's legal representatives in the Constitutional Court on Friday as the Commission sought to have the court postpone the local government election scheduled for October 27th to next February. Now, the virtual sitting saw the IEC argue because of the pandemic it could not organize constitutionally compliant elections this year. The Commission asked the question to the court to declare that the failure to hold the municipal elections by November 1st of 2021 is unconstitutional and invalid, while suspending the declaration of invalidity up until the end of February of 2022. But some tough questions hang in the balance, and to explore these questions and get some sort of answer here, we speak to Research Officer at CASAC, Dan Mafora. Dan, a very good morning to you. Thank you so much for your time. CASAC has been very clear on its positions when it comes to whether or not elections should be held this year or next year. CASAC has been very clear to say that the Concourt has no legal basis to stop elections from going ahead. In fact, saying that the IEC's request is an attempt at backsliding out of constitutional obligations. As you watched things playing out in the Constitutional Court yesterday, what did you make of the orders?
Good morning, Paul, and thank you so much for having me. The hearing yesterday revealed, obviously, that the court was giving serious consideration to the question whether it has the power to actually grant a postponement of elections, but also importantly, what happens if it doesn't have that power? How do we solve the kind of practical issues that the IEC has raised around organizing an election before October or before the 1st of November? And so my sense of the hearing yesterday was that the court, the majority of the court at least, was not convinced that it would be able to grant, in terms of the Constitution, the IEC a postponement, since Section 159, which governs the term limits of municipal councils, is very clear that an election must be held within 90 days after the expiry of a municipal term. And so what we are seeing now is the court asking for solutions to say, in the event that we don't actually have this power, how do we get around some of the difficulties around organizing voting registration weekends, having the voters roll open? How do we make sure that, to the extent possible, we ensure that this election would be free and fair?
Dan, what was really repetitive in the line of questioning as we listened into the full bench of judges there was the question posed to the IEC as to why the Commission did not approach Parliament to make this decision as opposed to heading to court.
Absolutely. So the Commission doesn't actually explain why they never explored the option of having Parliament consider whether or not it should amend the Constitution, maybe to allow an exception for this year's election, to say the election scheduled for October 2021 may be held at a different time. What became clear was that the IEC thought that it would not be able to get a constitutional amendment through Parliament anyway, and so decided not to explore that option. But obviously, they recognized that they would need a constitutional amendment in order for them not to hold elections before the 1st of November. And so that became a very important question to say, why have you come to the court when we don't know whether or not the court has this power, if you had the option of going to Parliament earlier and asking it to consider whether or not to amend the Constitution?
At one point, with that question being posed so many times, the IEC's advocate Wim Trengrove then said, we are not asking the court to amend the Constitution. And then you had another judge saying that it seems as though you are asking the court to amend the Constitution, but not being upfront about that. Does the Constitutional Court have the powers to then postpone these elections?
Honestly, on the text of the Constitution and what we understand the processes around amendment to be, it would be very it would be very surprising for the court to say that it has the power to amend the constitution. And of course, the IEC has tried to kind of craft this argument around we're not asking for an amendment. What we're asking for is simply some kind of exception to the rule or some kind of suspension for us of the constitutional obligation. But that in itself, of course, would amount to an amendment, because the section is quite clear when elections need to be held, and holding elections, whether because of a court order or something else, would be an amendment of the provisions of that section, which are very clear about when elections should be held.
And would you think that ruling on this matter would infringe on the separation of powers, should that decision then be made?
100%. That was the argument that was put forward by one of the parties to say, if the court allows itself, or if the court orders that the IEC can hold elections after a time period that has been set by the Constitution, that would be a violation of the separation of powers doctrine, because the court would have done the job of Parliament.
And in the second bit of line of questioning with Advocate Butlender, questions around whether or not the IEC may have failed to prepare adequately for these elections. That was also put forward and posed as perhaps another line of argument as to perhaps an indication of where the court is trying to get to when it comes to the final decision.
Absolutely. So the IEC really finds itself, maybe by its own creation or otherwise, in a very difficult place. But it still has not been able to explain in full detail why it took the actions that it took so late, so close to the elections, having known, right, since March 2020 that the situation in the country has changed and that they were not able to have elections in the normal ways that they would usually have. And so we don't know why, for example, there was no approach to Parliament, why they waited until May to commission the report on the Moseneke, or the report by Justice Moseneke, why we did not have a voters registration weekend earlier in the year when infections were low. And so these are the kinds of questions about the IEC's own preparedness that they have not offered answers to. And it does seem to an extent that it might have been a self-created crisis.
As you speak about the Moseneke inquiry, another question was posed around the outcome of that very well-researched inquiry, where questions around the practical difficulties should we find ourselves come February 2022 in a similar or perhaps even worse situation as a country, especially considering the vaccine reluctancy that we're seeing as of late. What would that mean? What would that then mean for elections should they be postponed to next year?
So, exactly. So, in the Moseneke report, you'll remember that Justice Moseneke discusses the divergence of opinion between the experts about whether or not, or whether October or February next year would be a safe time to have these elections. And obviously, some of the experts were of the opinion that October would actually be safer than February 2022. But it is very important now that you've mentioned vaccine hesitancy, that there might, the whole reason that the IEC has gone to court is to say, based on the Moseneke report, we expect vaccinations to have covered a large portion of the election, of the population rather, for us to be able to have elections without risking a spike in hospitalizations, in mortalities. But now the situation has changed, And now we know that the experts are not united on the epidemiological data about whether or not it would be safer in October to have elections than in February. And so the question then is also that what happens then? Do we go back to court and ask for another postponement, or would we risk having elections in a worse circumstance?
Was there some substance to the argument that was put forward by the IEC's legal representatives when they spoke about the differences in political parties, saying that perhaps a political party like the DA, which has a sophisticated database and able to access voters with other means because of the resources that they have, as opposed to a poorer political party that would need door-to-door canvassing and holding rallies to then bring out their message. Is there some substance in that line of argument when it comes to perhaps a reason why elections should be postponed to next year?
Well, there might be some merit to that argument, but of course we know that local elections are very different from national elections, and so the dynamics are different. It might be arguable that in a national election you need to have the kind of modes of campaigning that you're talking about, hosting rallies, doing door-to-doors. Local government elections are closer and more apportioned, if I may use that word, in a way that parties are able to have direct contact with voters in smaller capacities, in a way that would not necessarily have to, endanger any person involved. And so, while obviously the parties have an interest, in holding rallies and having the faces or prominent faces in their party kind of rile up support in all of the municipalities where they're contesting elections, but whether or not that rises to the level of something that might affect the freeness or fairness of an election is questionable.
And very lastly, Dan, before we let you go, what would you foresee here as the main challenge when it comes to this matter, especially with the sort of research that you've conducted?
So definitely the question around jurisdiction, whether or not the court has this power, that would be quite a radical finding by the court if it were to find that it has this power. And it would have to motivate it quite strongly. But also, if the court finds that it does not have this power, it would have to craft a remedy that navigates some logistical issues around how do we organize a voters' weekend, how do we allow for the voters' roll to be inspected and objections to be heard in time for the October 27 elections, and that might also involve having to suspend certain pieces of legislation, regulations, and such. And so the court does have a very difficult job of trying to balance and to motivate the reasons for its decisions. Either way it goes, whether it grants the postponement or dismisses the application.
Absolutely. Stuck in between a rock and a hard place. Dan Mafora from the Council for the Advancement of the South African Constitution talking to us there about what we saw playing out in the Constitutional Court and some tough questions being asked there of the Commission.